All right, we'll start with our study of civil law. What is the civil law? Well, the civil law is the oldest, the most influential of legal systems. And when we talk about the civil law, what we're really focusing on is a codification of the law, a systematic codification of the general law. Now, the civil law has a heritage drawn from the Romans. The Emperor Justinian decided that there should be laws that were drafted to cover the situations that people commonly face. And so what the drafters of what came to be called the Justinian Code, the very first civil law, was what they did is they looked at the world, they looked at customs, and they put those customs into writing and made them the law. And they did it in a very systematic way. If you look at civil law, whether it's the Justinian Code or the French Civil Code or modern German Civil Code, you'll see that there's a lot of elements in common, but the most important is that it is systematic. It's like an outline of all of the types of issues that could arise, whether from crime or whether from contract or whether from tort. And then there's a description below that, subheadings, of what the law should be. Now, the French Code Napoleon, the French Civil Code, many scholars regard that as the most influential document in the history of the world. Certainly the most influential legal document, because most of the world's legal systems are based on the civil law, and most civil law is drawn, at least in part, from this early French Civil Code. And so we'll talk about the French Civil Code and its effect on the development of civil law. The French Civil Code emphasized clearly written and accessible law. Now this Civil Code was developed following the French Revolution, in which the French king was thrown out, beheaded, and replaced by a democratic system. And the ideas of the nobility and the common people were discarded. And therefore, the French Civil Code placed an emphasis on accessibility, that the law should not only be written down, but it should be findable, that anyone, regardless of educational background, should be able to go look it up and see what the law is. So accessibility is important in a civil law system. And we'll see this idea of accessibility is going to really distinguish the civil law from the common law. Now, as I said, the civil law gives precedence to written law, law that comes from a legislature. The civil law, the most widespread of legal systems, all the new countries that have been created since World War I have almost universally adopted the civil code as their dominant legal system. The civil laws found throughout Europe, with the exception of England and Ireland and Scotland. In those countries, they follow the common law, but throughout the rest of Europe, they follow the civil law. And in fact, with the exit of the United Kingdom from the EU, that will leave only one country in the EU that still follows a common law tradition, and that's Ireland. Most Central and Latin American countries use the civil law system. Many African and Asian jurisdictions have also modeled their law on the civil law system. So it is widespread, it is around the world, and it is the type of legal system that is overwhelmingly adopted by new countries. Now, civil law systems share certain characteristics. And the first is they are secular. Civil law systems are secular. They derive their power from the people. And again, because now we know that the French Civil Code affected the development of civil law, the French Civil Code, written after the Revolution, an emphasis on the people, and the people speaking and becoming the ultimate sovereign, civil law systems are always secular. And they tend to be capitalist as well, meaning they are based on the idea of preserving property rights. Property rights are just as important in a civil law system as they are in a common law system. Now, civil law systems, again, rely exclusively, almost exclusively, on written sources of the law. When we talk about the common law, we're going to see that there's a lot of times where the law may not be written down somewhere, but that's not the case with the civil law. In a civil law system, their view of the law is necessarily state-centered, meaning the state creates the law. And so in a civil law system, the state and the law are essentially the same thing, because the law can't exist without the state. So in common law systems, such as found in the United States, we tend to think of the law as being outside of government, outside of the state. We believe that the government is bound by the law in the same way the people are bound by the law, that it exists over the state. But in a civil law system, the law and the state are the same thing. So when we talk about their view of the law as state centralized, it means that the state can't violate the law because they are the law. An act of the French legislature is the law. It's not subject to review by the highest court, because if the state did not pass the law, it can't be the law. Now, law is seen as a means of settling disputes authoritatively. And in a civil law system, we rely heavily on professionals. I say professional lawyers, but professional judges as well. They are people whose job it is to administer the law, to enforce the law. And as we'll see when we're comparing civil law and common law, for instance, a civil law judge is just a mid-level bureaucrat. He is not the elevated personage that he is in the common law. He's not Your Honor. Instead, he's just Mr. So-and-so. That it's a professional emphasis. Now, having said that the law and government are the same thing does not mean that the government is free to do whatever it wants to do, because it's based on the rule of law in the sense that government authority is constrained by legal rules and procedures. The reason we write these laws down is that we know what the laws are. So civil law systems, even though they are state-centered, does not mean that the state's not bound. The state is bound by the law in the same way that the individual citizens are. Now, civil law systems accord great importance to personal rights, human rights. And again, going back to its heritage following the French Revolution, in which there was acknowledgement that everyone is equal and that everyone has certain human rights simply because they are human. There are certain fundamental rights. And so civil law systems invariably acknowledge these human rights.